Right.
Good morning.
All right, I'm gonna wait on you, okay?
Good morning. All right.
We'll waive probable cause, Your Honor.
As to bond.
Mr. Tamang is 29 years old, tells me he's homeless. He does not work at this time. He has no money for bond. I understand that he is being held on a $10,000 straight bond on a misdemeanor that was in recently. He spoke English to me. He spoke English to the qualifiers earlier today. However, for future proceedings, we would ask for a Nepali interpreter.
From the state.
Your Honor, given that there is a pending case, and then this seems to be of similar action, state will be requesting a high secured bond. Allegations are that he set 2 different trash cans on fire, both of which are owned by the city of Cincinnati. This is based on fire investigation and video surveillance that observed him setting the fires in the trash cans.
Do you have anything where they were located? Were they by structures?
I'm sorry.
Were they by structures, business, or residential?
They did list an address of 326 Ludlow Avenue and 319 Ludlow Avenue.
I couldn't tell from the complaint whether any people or structures were actually in harm's way.
There's 1 pending charge, which is arson, 2 prior failures to appear. These are felonies of the 5th degree. The new charges, $5,000 anyway, plus EMD. It'll be the same bond on the other, which is $10,000 secure. That was already set.
Grand jury date, January 15, 1/15. Ricks.
Riggs.
Good morning, Your Honor.
Right in the middle, and see your attorney can get the wait on you.
Not guilty for Miss Ricks. She is an early call, Your Honor, because she does have some matters set for trial over in municipal court this morning. I'm not sure why this lags behind. She is denying the allegations. She works for Rick's Detail. She's also working on getting into nursing school. She has 2 children at home, ages 1 and 5. Does live here in Cincinnati. She's a lifelong resident. All of her failures to appear, she indicates as well, are driving charges. She does want to make this court date. I would note there was a lag in filing this charge. It's alleged that it happened on November 10th and it wasn't filed until December 15th. So we just ask you to take that into consideration. She is out. She was planning on being in court today for the other matter. She will return for this.
From the state.
It's an alleged theft of merchandise items from Dillard's, asking for a stay away, no contact with Dillard's.
$1,000 anyway, plus EMD.
Pablo. This other one.
I'm sorry.
Pablo?
Not yet.
Morning, Your Honor. Who went for the break?
Not guilty for Mr. Pablo.
As to bond.
As to bond, he's 48 years old. He's been in Cincinnati for the last 20 years. Your Honor, he has given me good contact information. He does roofing. He's full-time. He's been with the same company for the last 2 years. Yeah, he's not a flight risk, no failures to appear. I don't see any convictions on his record either. Asking the court to consider an OR or SOR.
From the state
State will defer, he gave a false name to police.
supervised OR, there is no record, no prior failures.
Thank you.
Is this with the different case?
They're part of the same series of events. The misdemeanor charge is also on Ludlow Avenue. It's part of the same investigation, from what I can tell.
Give it all the just put it with what you guys have. No, they want to see it. If you- Okay, just, okay, all right.
So that'll go to the grand jury judge?
Yes.
Yeah, thank you.
Yes. Before we start the next docket, I have a search warrant. One minute.
Stay too long, too long. They can talk more than that.
This one is.
Connor, is this your assignment?
No, well, kind of. So I'm in grand jury now, and we're taking over again, and we're doing rotations. So the
Court is back in session.
Yeah, that's what they're after me.
Okay.
Tommy Craig, request for temporary protection order. There are no full attendance. Marisa Bell Rodriguez present.
Is this the prosecuting witness?
This is your mother?
I'm not sure if my mother was. Okay. That's Mr. Craig's mother.
Okay.
Please not hit.
All right, Esteban.
Judge Esteban, I'll note first that this is a 2024 case, over a year delay between the complaint and today's arraignment. Mr. Craig turned himself in over the weekend once he learned this warrant. He does not stay with this prosecuting witness, has an alternate address. He just signed a protection order, 0 failures to appear, very limited record. his sole source of income is SSI. That has been the case for the last 7 years. He has 2 children, 13 and 18 years old, both currently staying with his mother, but he provides for them, cares for them, takes them to school. They rely on him. Given the age of the case and the fact that he signed this protection order, we're asking the court for an OR bond.
From the state,
Your Honor, allegations are a slap across the face and a bite to the victim's middle finger. State would request EMU and jurist if requested by prosecuting witness.
Mr. Craig has 1 misdemeanor, 0 failures to appear, nothing that is violent. This particular case is from December of 2024. So we are on the 13th month from the date of the alleged incident, or a little bit over 12. This is December 30th. In between that time, obviously nothing has occurred, because if it had, he would have been here before today. So the court, did he execute the TPO?
Yes, Judge.
He's executed the TPO. The court is not going to order any further monitoring at this time outside of the TPO, OR plus the TPO.
Thank you, Judge.
Next is Tara Gear. And there's a request for temporary protection order.
Here.
Sir, Tony Williams present.
Mr. Woods? You have an idea?
Judge Will Porter, on behalf of Ms. Gear, she's making her way out here. The plea will be not guilty. It's my understanding the prosecuting witness is here. I would like the court to hear from him first.
What's the name?
Tony Williams.
Oh, yes, sir. What would you like to say?
I'd just like to say, just get here from Florida. I live in Florida now. Been here for probably a couple of days now. I don't want to press charges. Trying to see if I can get this thing dismissed. I know she's having a bunch of health problems now. I haven't seen her about 2 years. I don't want anything bad to happen to her.
Are you concerned for your safety?
Oh,
Safety of any children?
No.
Do you want a TPO?
No.
All right, thank you, sir.
Thank you.
Is there anything from the state?
Defer to the court.
This case as well is from 2024. It's from May of 2024. The prosecuting witness, the court will take that request into consideration as well as the age of the case. Ms. Gear has no prior failures to appear. There are 2 prior violent misdemeanors, but obviously nothing has occurred in the past year and a half because she has not been here. So the bonds on those will be OR. All right, thank you.
To Marion Gooch. Sir, Desiree Cade present.
Middle, next to your attorney right there in the middle.
Mr. Gooch.
You got full attention, please, Judge.
Judge, please not guilty.
What happened to the underlying case?
That case was dismissed, Judge, for want of prosecution.
From the state?
Your Honor, it looks like the allegations are defendant attempted to contact victim via cell phone. That's the extent of my knowledge about the case right now. Defer to the court.
Mr. Gooch has no record as an adult or juvenile, no prior failures to appear. The underlying, this was a pretrial protection order. The underlying case was dismissed. This also is alleged to have occurred August of 2025. Bond of the OR.
Thank you, Judge.
Victoria Grimes. There's a request for staff.
Grimes.
Is there a Justin Phelps?
Judge, the plea is not guilty. If I could just have one quick moment. Judge, the plea is not guilty. Ms. Grimes is signing the protection order. She will be staying with her aunt during the pendency of this case, so an alternate address away from the prosecuting witness. I see one failure to appear, one conviction of any kind in the last more than 10 years. She has been working with temp services here for the last couple of years. Was actually packing her things up to move to another state. In fact, when the alleged argument occurred, given the fact that she's signed this TPO, she doesn't miss court. We have great contact for her, and she'll be staying away from this prosecuting witness. We'll request an OR bond from the court.
From the state,
Allegations, Your Honor, that the defendant struck prosecuting witness in the right arm with an iron skillet. State would request a monetary bond and EMD and juris if requested by prosecuting witness.
Judge, if I may add, there's a child here that obviously had nothing to do with this incident. He's 1-year-old who's scheduled for surgery later this week and is obviously very dependent on Ms. Grimes to ensure that that happens and that goes smoothly. Would add that as a reason to release Ms. Grimes.
Ms. Grimes has 5 prior misdemeanors, 1 prior failure to appear. Out of those 2 misdemeanors, though, there were 2 domestic violence charges that were amended to disorderly conducts. $5,000 anyway, plus juris if requested.
Destiny McCrory.
Their sisters.
McCrory.
Who is it? Let's go to the next.
Next be a
Jared Baker.
Jared Baker.
Good morning, guys. Any witnesses from Northern Tool and Equipment? Response.
Right in the middle, next to Keith, so we have to wait on you, okay? Got full attention, face the judge.
We will waive probable cause, enter a plea of not guilty for Mr. Baker, Your Honor. As Bond, thank you, Judge. Mr. Baker is 30 years old. I have good contact information for him, Judge. Is the proud father of a 3-year-old son that he helps to care for. He is employed at Monty Inc. It is a manufacturing plant. He tells me he's been there about 8 months, Your Honor. He says he actually is supposed to be at work today, Judge. I show a minimum record for Mr. Baker. I don't see any prior felony history, 0 failures to appear, Your Honor. Due to this being a low-level felony, nonviolent felony, I would ask that the court would consider an OR bond due to him not having any failures to appear.
From the state,
Your Honor, state is going to be requesting a minimum EMD lockdown. These were two separate days where the defendant took tools from Northern Tool and Equipment. He was eventually identified by a number of different means, including clock camera, security footage, and then the employees at the residence. When they did eventually make contact with Mr. Baker, he did say that he took the items and sold them to pay for methamphetamine and fentanyl. I believe there might be an out-of-state record, seeing as Hamilton County contacts appeared limited, so we would request EMD.
there are 3 misdemeanors. There are out-of-county records, as has been stated. Theft and drug offenses. There are 0 prior failures to appear. Mr. Baker lives in Hamilton
Yes, Your Honor.
and works where? What side of town is it?
Monty Incorporated. I work in Reading, Ohio. Well, it's Norwood, Cincinnati.
Do you know where this is? It's Northern Tool and Equipment.
It's in Sharonville. I'm sorry.
Yeah, this is 2275 Crown Point Drive in Sharonville.
Give me the address again.
2275 Crown with an E, Point Drive.
OR plus EMD with a 3-mile radius from 2275 Crown Point Drive. If you go within those 3 miles, they're gonna pick you up. Understand?
Right.
Stay away from Northern Tools and Equipment, and random urine screens are a condition of.
Your Honor, could you know, I've had issues in the past, if he can be on EMU in Butler County, please?
Yes.
I'm good.
Grand jury date, January 15, 1/15. Let's go for Kennedy.
Get the water, please. You have to get the
You ready on recording?
We are, Judge. I apologize.
Rory?
Is there an Alicia McCrary present, Rory?
Your Honor, this is Dustin McCrory. The plea is not guilty. There is a temporary protective order request. She's going to sign that. The alleged victim here is her sister, who is an adult.
Are you sister? Do you have your ID? All right, you show it to the deputy.
Checking in as I approach Ohio, I see cars for a, Alicia McCory.
All right, what would you like to say, ma'am? Come on up to the box. I can't hear you.
I would like to drop the charge.
All right. So once the charges are filed, it becomes the state's case, so it won't be dropped today. But do you want a protection order against your sister?
No, she had the baby at home.
Are you concerned for your safety or the safety of anyone else around you?
No,
Has anyone threatened or coerced you to be here today?
no,
All right. Is there anything from the state? She has no record as an adult or juvenile, no prior failures to appear.
Defer to the court, Your Honor.
And Your Honor, the police bond preference is low bond. I would ask for an OR.
Or. All right.
And no TPO.
Thank you. She'll be released shortly.
Back on county felony docket. Barton, Dramar Barton.
Your Honor, in regards to the felonies with waive probable cause, we are going to be asking for a nominal bond because he has a holder, but I would like to tell you a couple of good things about him before speaking to misdemeanor. He's 27 years old. He's about to be a father for the first time. Most of last year, he did have a job at Par 3. He's from Cincinnati. He graduated from Hughes, and he has part of his college degree working towards business management. As I stated, he has a holder, but we would ask for just a nominal bond.
From the state,
Your Honor, state will be asking for a secured bond of firearms as a condition. I believe the defendant does pose public safety risk. There's currently a city assault pending. In this particular matter, defendant is currently on parole for robbery and felonious assault from 2016. Started out as a traffic stop, and officers located a firearm under the driver's seat.
And Your Honor, I don't think it doesn't say anything, nothing about a traffic stop. It sounds like a car was parked somewhere that he was close to. Just for clarification, but like I said, we're still asking for nominal bond.
did you have anything you want to add?
Just that the assault is being arraigned today for the first time. There's nothing pending from Mr. Barton at this stage until today's arraignment. Would ask for a nominal bond on the misdemeanor as well. It's a completely separate incident, so not guilty and referred to the assignment commissioner, please.
Do you have the assault complaint?
I do.
Okay, what is, can you read it?
Yes, allegations are that defendant struck, looks like Erin Simpson. He punched her in the face, pulled her hair, and kneed her in the stomach.
Judge, that allegation is from October of last year.
Of 25?
Yes.
There are 2 prior violent felonies, 0 failures to appear. Looks like Mr. Barton is still under supervision. On the CCW, 5,000 anyway. Having weapons under 10,000 secured, improper handling, 2,500 anyway. 5,000 anyway, plus juris on the assault.
Thank you, Honor.
Grand jury date January 15th, 1:15.
Is that on everything?
No, just on the
Floyd.
Sean Floyd. Request for protection order, temporary protection order.
Thank you.
Oh, no, you're fine. Oh, I didn't know you had this. Oh, there's another.
Thank you. Jamari Hughes or Jamila Robinson. No response on prosecuting witnesses.
Waive probable cause.
Your Honor, sorry. The forgery, I represent on the forgery, the domestic violence, and the criminal damaging. Waive probable cause on the felonies, enter a plea of not guilty in regards to the misdemeanor. As to bond, thank you. It appears that there's only one prosecuting witness, that the other person that was called for was potentially a witness, just to make that clear. Sean is 34 years old. He graduated from Coleraine. This case, the alleged domestic violence is from 12/9 of 25, and the alleged forgery is from 11/8 of 25. Sean actually turned himself in yesterday. He's been living in the same home. Nobody's tried to show up to find him for 15 years with his mother. Never been to prison, has 2 kids, ages 6 and 10, whom he sees often. He has been working for almost a year as a machine operator at Iwatabolt. IWATA. Okay, you've heard of it. He had to spell it for me.
No, I have it in front of me.
Oh, okay. Your Honor, we are asking for an OR supervised OR bond, or he is signing the TPO, or $1,000 at 10% on each of the felonies.
From the state.
Your Honor, with regard to the forgery, state will be asking for a stay away from Jose Rodriguez and Tres Los Amigos. Defendant does have a prior conviction for passing bad checks in 24. Allegation here is that the defendant paid with a fake check. We'll defer us to bond on the remainder of that. On the domestic violence charge, state will be asking for EMD jurors if requested, no firearms as a condition of bond. Defendant has a prior conviction for domestic violence in 2016. In this case, the prosecuting witness is the sibling, sister of the defendant. Allegation is that he threatened her with a firearm and threatened to kill her. This was witnessed by another person and occurred at, I believe, their mother's residence.
There are 4 felonies, 1 violent misdemeanor, 6 misdemeanors, 6 prior failures to appear. You say he's executed the TPO?
He has, Your Honor.
Did you have anything
I have
on
a
this?
city traffic case, TRD 22424. We'll be not guilty on that. We're requesting our bond there as well. I recently represented Mr. Floyd, so while he may have failures to appear over the past 5 years, he and I worked through the entirety of the case, resolved one just a couple months ago. We have good contact. I believe that he'll be in court to resolve that case as well.
Well, what happened with this one? If you saw it a couple months ago, this from December.
Okay, a couple more months ago. This is when I represented him before this case arose.
And I would remind the court that he turned himself in. They never tried to find him.
On the minor misdemeanors, traffic, OR, on the driving under OBI suspension, the KPS bond was $1,000. It'll be the same bond or alternative OR EMD. On the new DV, 5,000 anyway, plus jurors if requested, no firearms. Criminal damaging, 1,000 anyway, forgery, 1,000 anyway. I'll do, the alleged check was $300, it'll be 1,000 anyway, or alternative OR EMD. I'll do the same on the criminal damaging, I'm keeping the DV on cash.
Grand jury date 1/15, January
Right, sir.
15. And that is on 2 felony charges. Paul, Jeremy, Paul.
Sir, all. Real next to your attorney, they're waiting on you, okay?
Tell me when you're ready. I'm sorry. I just don't want to interrupt. You ready? Okay. This is a series related to an OVI. The reason there's just one felony related to improperly handling a firearm that was allegedly found in the car. So it should all be together, it appears. Your Honor, Mr. Hall is 36 years old. I'm sorry, that was one thing I didn't write down. He's 36 years old. He's lifelong Cincinnati resident. He has 0 failures to appear, and he has an ORIS score of 2. He does have 6 children, ages 18 down to 8, and his wife of 20 years. They all live in the same home. He has a job at University Hospital where he does patient transportation. Unfortunately, back in August, he tore his rotator cuff in the left arm. which is the arm that the police tried to assist to getting him out of the car. So he's in a lot of pain. I think there's going to be more of a story besides him not being nice to police is what I'm trying to say to that. He did have surgery back in August. He's still out on disability leave. He's been in his current home for the past 6 months. I do have a good number for him and his wife. Your Honor, at this time, he is not able to come up with any money. He understands he cannot drive and he has to stay away from all guns at this time.
From the state,
Your Honor, officers are requesting a high bond in this case. This started out as a marked lanes violation that turned into an OBI investigation. Defendant was driving through a school zone in Springfield Township about 3:40 in the afternoon when officers first observed him. So he was slow to pull over, so officer called for assistance. When they initiated an interaction with Mr. Hall, he very quickly became combative, refused to cooperate with them or any of their commands. They did end up having to take him into custody. He did resist. Took a couple officers to actually get him in cuffs. And then when they searched the vehicle incident to arrest, that's when they located the firearm that was in the backseat of the vehicle, looked to officers as if it had been tossed in the backseat prior to when he actually pulled the car over. Your Honor, there is also one prior obstructing official business conviction that, according to an officer who's here this morning, was also a violent interaction with officers. Based on the time of day and the allegations here, as well as his history with officers, state's going to request a high bond.
what number OBI is this?
First lifetime, refused all tests, no accident, no injury, no insurance, and there is an ALS on file.
The resisting, is it 2?
Yes, M2 is what it's listed as, Your Honor.
Yes.
How far was the failure to comply? Does it have, how far? did
It's
it
charged as a
comply?
misdemeanor, if that's helpful.
It did not put a distance in the complaint. Yeah, there's no distance in the complaint. The officer that was here earlier was doing warrant service for something unrelated, indicated that it was long enough of a distance after lights and sirens were activated that the officer called for assistance because he wasn't stopping. That's the only information he gave me.
Their Form 527 says the vehicle continued a short way. So I would ask for you to take into account that they claim in their writing that it was just a short way.
On the OBI, it's first ever. It'll be OR plus TAD plus no alcohol. On the marked lanes, minor misdemeanor OR. The improper handling is F5. $5,000 anyway, or alternative 2,500 plus EMD. They're resisting $5,000 anyway, or alternative 2,500 EMD. Failure to comply $5,000 anyway, or alternative 2,500 plus EMD. Those are the misdemeanors. The open container in a motor vehicle.
Your Honor, I would ask if with the EMU, if you'll make that lower, because that's still $7,500. if you consider OR EMU or $1,000 anyway with EMU.
Gun, I'm keeping the same. The resisting, I'm keeping the same. I'll change the failure to comply to 1,000 plus EMD. All the other ones are the same.
Thank you.
Grand jury date, January 15, 115, all cases.
Oh, thank you.
Harmon, Dwayne Harmon,
It looks like Dwayne and Wayne are the same people.
Dwayne Harmon? Yes.
It has the same control number. I don't know if they entered it wrong. I
think so.
have Dwayne Harmon and Dwayne. Is it Dwayne or Wayne?
Make sure you're turning one the other way now, young man.
I think.
You get everybody got full attention,
It's Dwayne. Good morning.
Good morning, Your Honor. We'll waive probable cause.
All right, ask the bond.
As to bond, Mr. Harmon is 35, Your Honor. He does have multiple children, ages ranges from 3 to 16. He works as a paraprofessional in a after-school program, in the summer program. He does have a GED, also have a certificate in early childhood education. I see only an OR score of 1, only 3 failures to appear. His only criminal history that I can see is the theft charge that is referenced by the officer. He has no history of violence. We would be asking for another one.
From the state.
State asked for no firearms as a condition of bond. Started out as officers would observe the defendant riding a bike on city sidewalks. Went to interact with him, and during the interaction discovered that he had a firearm on his person that was registered to his wife. He did have 1 conviction for theft out of Kentucky that made him ineligible, as well as warrants that they served at the time.
Was it the theft of a gun?
No. At least it doesn't say on here.
Incident report I has says defendant indicated to officers he was convicted of a work theft offense in Kentucky. Felony work theft offense.
Mr. Harmon has the 1 theft offense, no other record, no prior failures to appear. And to be clear, the allegation is not that he can't have a firearm, it is that he can't have it concealed. Is that the state's contention?
I believe that is my understanding, yes. Yes.
On the bicycle violation, OR, on the CCW, OR plus EMD open hours, the EMD is because Mr. Harmon has the 3 prior failures to appear.
Grand jury date, January 15, 115.
Thank you. Thank you, Judge.
Harris.
Durensis.
How do you pronounce it?
Right back in, or plus EMD, juvenile.
Durensis. Oh, sorry.
Request for a temporary protection order.
Are you the prosecuting witness? Do you have your ID?
Like in the middle, if you're turning, we either make you a full.
One second, the deputy will come look at it. Yes, ma'am. What would you like to say if you're just talking to the box?
We do share a child together. It's just a big misunderstanding. Alcohol was involved on both parties, and I just don't want to prosecute you.
Are you concerned for your safety or the safety of your child?
No,
Has anyone threatened or coerced you to be here today?
no,
Do you want a protection order?
no.
All right, thank you, ma'am.
As to bond, we waive probable cause in regards to the felony and enter not guilty in regards to the domestic violence and assault. All of those should be together, it appears. It appears that the domestic violence and assault have been charged in the alternative. The robbery alleges the same alleged victim, and all it states is property was taken. So we're back to the whole charging people with felonies of the second degree in these types of situations. So it's not like he went somewhere with a gun and stole something as you would expect to see in a robbery. Your Honor, he did turn himself in yesterday. He's 36 years old. Prosecuting witnesses present says she doesn't want to go forward. He's from Cincinnati. He has 5 children. He's a full-time dad to his older children. He does live with his mom, where he's been for the past 18 months. We're asking for supervised OR.
From the state.
Based on the nature of the allegations, state will request no firearms as a condition of bond.
There were no allegations of guns, so that's not a problem.
There are 7 prior felonies, 6 misdemeanors, 1 prior failure to appear, no convictions of violence. Prosecuting witness is present and doesn't want a TPO or to proceed, even though the robbery is a felony of the second degree. The facts of what occurred do not align with setting a bond that would be the same as a bond as if someone went into a store with a gun and robbed the store. Supervised OR on the robbery. Supervised OR on the assault and the DV.
Thank you, Your Honor.
Grand jury date, January 21st, 1/21. Heaney, Richard Heaney.
Darren Nye for Mr. Heaney. I'll waive probable cause. I'll also waive his appearance. Mr. Bond, Your Honor, this certainly, I believe my client's wife is here in the courtroom. This, he's got, if he has prior felonies, the best I can tell, they were more than 30 years ago, Your Honor. He has a pretty unremarkable history. It doesn't appear as though anybody was injured in this particular incident. It's indicated in the paperwork this was a mental health crisis. It looks like he'd taken a lot of medication in an attempt to maybe commit suicide. So we're asking for a reasonable or OR bond. I did meet with him this morning. He seems to be coherent, know what's going on, but he's up on the psych unit. Looks like he'd called dispatch and maybe indicated that he'd taken the medication.
Had he been, where did this occur?
In his residence, I believe. But his wife is shaking her head yes.
I have here he was released from Good Sam January 5th. Was that a mental health hold? Okay, thank you. From the state.
Assaults on an officer, allegation is that the defendant kicked the officer in the thigh while they were trying to get him into custody so they could take him to the hospital. Officers did note that this was a psychiatric emergency run. I don't have on my paperwork what bond the officer would request, so I'll defer to you if you have that information.
I don't have a bond request either.
In that case, then given mental health history, state will ask for a minimum EMD lockdown.
Do you all live together? Is he employed? He has disability?
Correct. That's what I have, SSD.
Are you concerned for your safety if he is on lockdown at your home? There are 3 prior felonies, 3 misdemeanors, 0 prior failure to appear. The officer did know that this was psychiatric emergency responding to an attempted suicide by taking a large quantity of pills and did not want to go to the hospital. Are there weapons in the home belonging to Mr. Heaney? Are there weapons in the home, guns belonging to Mr. Heaney? OR plus EMD lockdown, no weapons is a condition of bond.
We just asked that he be able to attend any sort of medical or psychiatric type appointments, Your Honor.
Yes, defendant may go to medical and psychiatric.
Thank you, Your Honor.
Grand jury date, January 15, 1/15.
Herzog,
Right in the middle, Mr. Nye.
Darren Nye for Mr. Herzog. We'll waive probable cause, Your Honor. Is the bond?
All right, that's fine.
My client's 40 years old. He's got 2 children, lived here his whole life. He's got his GED or score 3, no failures appear in the last 5 years. He tells me, and at least it indicates that this firearm was on somewhere around the passenger door, that there was a individual in the car that the firearm's licensed to, a Miss Ramita Lumpkin, who had indicated to my client for whatever reason that she had this firearm on her when the police were walking up to the vehicle. My client had admitted that there was a firearm in the car when asked, because it's not his firearm. So we're just asking the court take that into consideration. He tells me he works at DWK Construction. He's worked there the last couple of years, and he can make a bond of $300 to $400, Your Honor.
From the state.
Defense counsel pretty much summed it up. The state will be asking for no firearms as a condition of bond. He does have convictions for aggravated robbery, felonious assault in 2012, that make him ineligible. Did note from officers that firearm was located on the passenger side of the vehicle. Defendant did disclose it immediately, and the passenger did indicate that it was her firearm.
There are 3 prior violent felonies, 2 felonies, 0 prior failures to appear. Looks like the last charge was from 2012. Oh, I'm sorry, I take that back. 2021 in Indiana. Based on the facts of the case, 0 failures to appear, the gun being, and the parties agree, what the officer put, the gun was on the passenger side. It was actually a passenger who said it was hers. It was not located on his side. It'll be a supervised or
Just give me a call when you get out, okay?
Grand jury date January 21/20.
You said January 20th?
Yes.
Okay.
Arrested 1/5. Yes. Herzog. No, sorry. Hollingsworth.
Good morning.
Sorry.
Wait, probable cause?
Yes, Your Honor.
All right. Mr. Hollingsworth has no record, no failures to appear as an adult or juvenile. Allegation is getting property of another, knowing that that property was stolen. Is there anything from the state?
Asking for a stay away from Gary Wilhoit.
Gary, who?
Wilhoit, Wilhoit.
OR plus stay away from Gary Wilhoit.
Grand jury date January 21/20. Honchel or Honchel. Request for an order of protection. Is there a Molly Honchel or Honchel?
Yeah. Good morning, Your Honor.
Waive probable cause.
Yes, Your Honor.
As to bond.
Your Honor, as to bond, the allegations in this case are from January 1st of 2024. It's a little over 2 years at this point. I would note that the conviction that elevates this to a felony is from 2005. Hold on 1 second. And that his last felony conviction was in 2013. He has no failures to appear for court. He is honorably discharged from the Marines. He's working as a bricklayer full-time. He's been at that job for 20 years. Your Honor, he is willing to sign the protection order. I would like to address one issue with the protection order, though. Melanie Honchel, is that your daughter that you have custody of?
Yes.
There is a Melanie Honchel listed on the protection order. That is his daughter. He's actually not currently living with his wife. He's living with his brother. He has full custody of that daughter. She's also living with him and his brother. So we would ask that she be removed from the protection order. She's 16 years old, I believe. If she's removed, he is willing to sign that order, and I have discussed it with him. Your Honor, in addition to that, we would be asking the court for an OR bond on this case.
And how do they do the parental exchange? Or do they?
Do you do any exchange, or is she just living with you? They have not done any exchange at this since he moved out with his daughter. I think he does have a brother. They're living with his brother, so I'm sure he could help if that came up and it needed to be done. But as of right now, he has full custody of his daughter.
I've taken the child off,
Thank you, Your Honor.
so it would just be Molly Honchel. And as to the new charges,
Judge, the plea is not guilty and they are not new charges, despite the fact that there is a 2026 case number.
Mhm.
These offenses are alleged to have occurred on the same day as the domestic violence. In the body of the complaint, January 1st, 2024, it was sworn on January 1st, 2024. So these are also a 2-year Sears issue. I don't know how it didn't have a case number until now. That's obviously a clerical error. I would challenge probable cause under this complaint to hold Mr. Honchel for the OOB or resisting. It's a very strange situation to me that an OOB and a resisting would not be arraigned given that they had him arrested. But the officer's paperwork in the 527 says that they took him to the hospital and apparently he was discharged, never arraigned, never told not to go anywhere, and obviously never arrested in the last 2 years until today. So we'd ask for an OR on the misdemeanors as well.
from the state.
Your Honor, allegations are the 24 case is that the defendant assaulted his wife by punching her in the face repeatedly. She did have visible injury when officers responded out to the location. Then he became combative with officers, complained of chest pain and had to be transported to the hospital, where his behavior at the hospital prompted them to place him on a hold. No further information about what happened after that point. Given that the protection order is executed, we'll defer use to bond.
The TPO has been executed against the prosecuting witness. These cases are over 2 years old. As counsel pointed out, he has not been arrested. Nothing has apparently occurred in the past 2 years unless he would have been in court before today. So the bonds will be OR.
Thank you, ma'am.
Grand jury date, January 120.
Sorry, did you say 21 or
120.
Okay.
Jeter, Darius Jeter.
We will waive probable cause, Your Honor. As to bond, Your Honor, the only violent felony conviction that Mr. Jeter has is from 2010. He's got no failures to appear and an OR score of 1. He is currently working as a CDL driver for Hilltop Companies. He delivers concrete. That is a very good job for him. He's very concerned about keeping that. He was off today, but he is supposed to be into work tomorrow. He does not live with the prosecuting witness in this case, Your Honor. This is someone that he knows. He's adamantly denying these allegations. He says this was sort of a family Christmas gathering, Christmas night into the next day. He can stay away from the prosecuting witness while this case is pending. We are asking for the court to consider a bond of $10,000 at 10%. From the state.
State will be requesting no firearms as a condition of bond. He requests a secured bond, EMD juris, if requested by the prosecuting witness. Allegations are that the defendant entered the residence by kicking open the back door and forcing his way in. Officers did observe damage to the door where he made entry, then attacked 2 males that were in the residence and was observed by another prosecuting witness who was the homeowner.
Do you have anything, any notes about if this was alcohol related or anything?
I do not have any notes that would confirm that, no.
There's 1 prior violent felony, 2 felonies, 1 misdemeanor, 0 prior failures to appear. Bond $5,000 anyway, plus juris if requested. No firearms is a condition of bond. Thank you, Your Honor. And there were no assault charges attached to this. Is that
No,
correct?
not that I've seen here.
Thank you.
Grand jury date, January 15, 1:15. Johnson, Renez Johnson.
There 9 for Mr. Johnson, Your Honor. I will not be waiving probable cause on this. I don't know if his underlying, or at least as it relates to the weapons under disability, I'm not sure if his underlying charge as CCW is actually a predicate for a disability, Your Honor. It's not a crime of violence or a drug offense.
What's the predicate? Tell me.
Looks to be a carrying concealed conviction, December 2 of 25. In front of First Path.
Does the state have anything as to the argument that the CCW is not a disqualifying offense.
One second, Judge. Just checking one thing here.
I don't at this time, Your Honor, unless defendant has a juvenile record, which again, I don't have access to in my office.
One misdemeanor as a juvenile, which was disorderly conduct.
I have no argument at this time, Your Honor.
Probable cause not demonstrated or bond on that. On the other two, the resisting and the CCW.
If there's no probable cause and there's not a grand jury report date, we just ask that the misdemeanors be referred to the assignment commissioner for probably a pretrial.
There is one prior felony, one prior failure to appear.
He's 19 years old. He tells me he's working at McDonald's. He's got a McDonald's shirt on, Your Honor. That's, lives with his aunt.
On the CCW, 5,000 anyway. Plus no firearms during the pendency of this case. On the resisting, 5,000 anyway, or alternative, 1,000 plus EMD open hours.
Is that a 1,000 on both or just the?
Mm-mm.
Okay, so the CCW stays at 5,000 anyway, and then the resisting could be reduced down to 1,000 with the MD if he can't make the.
Correct.
Okay.
There's a prior CCW conviction.
Then call me if you get out. Otherwise, I'm going to set it for a quick pretrial. Thank you, Your Honor.
Bertnisha Jones.
Jones?
Is there a grand jury rule? I'm sorry.
Yeah,
It doesn't have one. I love it.
Darren Nye for Miss Jones. We'll waive probable cause. It's the bond. My client's 36 years old. She's got 2 children she takes care of. She is currently at Community Matters trying to get her GED. It sounds like she admitted that she had this particular firearm on her when confronted by the police. She was compliant with them. And she tells me she can do EMU. It looks like her last prior felony type charge was maybe in 2011, which is roughly 14 years ago, Your Honor. Looks like in the last 10 years, she's basically had traffic type matters. And I don't think that there are any failures to appear, if I'm not mistaken, but maybe there was.
There was.
Okay. But we'd still reiterate that it looks like it's mostly traffic matters in the last 10 years.
Did you have anything you want to add?
Yes, good morning, Judge Riley Johnson. I'm a certified legal intern. I'm practicing the supervision of Will Porter, and I'm with Ms. Jones on the misdemeanor matters. And we'd like to resolve those traffic issues today, and we have an agreement with the state to that effect.
All right. What is the agreement?
State will accept the guilty plea to the 2 charges on the 25 ticket series ending 24468. It's an unclassified driving under suspension and a license plate violation.
Is the license plate violation a minor?
Yes, and we'll dismiss the other ticket in its entirety.
Ms. Jones, a guilty plea is a complete admission of guilt. The driving under suspension is unclassified.
Yes.
Is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. The unauthorized license plates is a minor misdemeanor. Maximum possible penalty is $150 fine plus costs. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the 2 traffic charges?
Yes, ma'am.
All right, I'll accept the plea. Counsel, do you waive and stipulate?
Yes.
Finding of guilty. How many nights has Ms. Jones served?
I
One.
believe one. One.
Is there anything else?
No.
One, credit one, we met the fines and costs from the state as to bond on the other charges.
Your Honor, I will request no firearms as a condition of bond. Defendant does have disqualifying convictions for trafficking cocaine in 2011 and aggravated assault in 2009. Defendant was a passenger in a motor vehicle that was pulled over on some traffic offenses. During that stop, she did have a handgun in her purse that was not initially disclosed to officers. Once they found it, she came clean with it, as well as ecstasy tablets and suspected cocaine.
And if I didn't say, she can do EMU at her current residence, Your Honor.
There are 2 violent felonies, 1 felony, 4 misdemeanors, 3 prior failures to appear. On the having weapons under 5,000 anyway, CCW 5,000 anyway, or alternative $2,500 anyway, plus EMD. The improper handling. $1,000 anyway, or alternative OR EMD. The possession, which is, these are F1s and F2s.
Yes, Your Honor.
That's how money help.
On the M4 drug paraphernalia OR, minor misdemeanor, open container OR, the having weapons under, which is a F3, 5,000 anyway, CCW, 5,000 anyway, or alternative 2,500 at 10% plus EMD, the improper handling 1,000 anyway, or alternative OR EMD, the possession, the F1 possession of ecstasy pills, 15,000 anyway, the F2 possession of cocaine, 10,000 anyway.
Grand jury date, January 15th, 1:15.
Sure, probably
Both
not today,
cases.
but I'll be able to see it.
Last
I'm-
name Jude.
What was
Amy
the date?
Jude, 1:15.
Thanks.
Thank you.
Jude? Jude?
Thank you. Yeah, may I hear probable cause, please?
I'm trying to read it, Judge. It's in plain all in pieces. On or about January 5th, officers were conducting an investigation at defendant's home. There was a search warrant for a blank video recording camera that was served upon the defendant at the residence. Defendant indicated that she had thrown the camera away in a garbage can with purpose to impair its ability to serve as evidence in that investigation. Officers did locate the camera recording system in question in a garbage can inside the residence.
Your Honor, I don't hear any allegations that Ms. Jude knew that a search warrant was going to be executed upon her home. So I don't believe that there's probable cause, so.
Can you read me what you have again?
Defendant did, with purpose to conceal or remove a blank video recording system to impair its ability to serve as evidence in an ongoing investigation. Threw that recording system in a trash can inside the residence. This has been part of an ongoing investigation that, according to this arrest report, defendant was aware of. She did admit to officers that she threw the camera away in the garbage can in an attempt to conceal it.
Based on the elements of the offense, the allegations meet probable cause.
Understood, Your Honor. Esteban, thank you. Ms. Jude is 29 years old. I have the contact information, resides here in Cincinnati, is the proud mother of 2 children, both under the age of 18, is employed at Amazon, located at the airport. She's been there about 4 months, Your Honor. Is a high school graduate. I show absolutely no record for Ms. Jude, criminal or even traffic, 0 failures to appear, or a score of 1, and that's only because she was under the age of 33 for her first arrest. I understand it's an F3, but due to her lack of record, no failures to appear, I would ask that the court would consider a supervised release.
From the state will defer. Supervised or There is no record, no failures to appear.
Thank you, Your Honor.
Grand jury date, January 21, 20.
121.
20. McCall, Lanaya McCall.
McCall. McCall.
Judge, we'd like to hear probable cause for the purpose of hearing whether or not the state knows the actual date that the alleged crime was committed, as opposed to what we think is in the complaint is simply the date that it was reported. And that's important because she's newly 18 years old. And we wonder if the state has information that the crime, if committed, was actually committed months ago.
From the state.
Allegations that the defendant did recklessly disseminate a video of a juvenile engaged in sexual acts. This was shared with a number of juveniles in separate chat rooms as well as on Instagram and Instagram Messenger. According to the incident report, prosecuting witness is 14 years old, reported that the defendant had been posting material of her in a state of nudity performing sexual acts. The video was recorded. The only information I have is a while ago. The suspect got a hold of the content and began posting it on social media. Reports indicates that there were more than 300 minors in one of the Instagram group chats.
Does it have a date that the defendant allegedly disseminated the video?
August 20th of 2025 is what the report date indicates.
And that's what I'm saying. That I understand that's when it was reported. I appreciate the information that a while ago, the defendant allegedly did something, and that's very important because her birth date is August 2nd of 2007. And so, yeah, I realize maybe we can't get to the bottom of that right here, but if we're going a while ago from August 20, I think it's fair to say jurisdiction is not proper in this court.
The indication on the report is that the video was made a while ago.
But
It looks like from my report that the defendant disseminated the video on Instagram, on or about August 20th of 2025.
If that's the allegation, that's fair.
So probable cause is found if it was disseminated regardless of when it was made and it involved a juvenile. The date of dissemination or dates is what matters to the charge.
And I agree with that. We just think the alleged dissemination, we might uncover it later, may have been much earlier.
Probable cause found as to bond.
Ms. McCall's 18 years old. She lives with her parents in Price Hill. She is a graduate of Achieve Point Career Academy. She's not employed right now as she's still living at home with her parents, but she has no money to post for bond.
From the state.
State will be requesting a secured bond, stay away, no contact from the prosecuting witness who is identified as AA, or the initials of the juvenile victim in this case. Obviously, this is of concern to the state as well as to the victim, particularly given the number of individuals that this material has been disseminated to allegedly. So we would ask for stay away, no contact by any means, including social media, regarding or directly to the prosecuting witness in this case.
There's no record, no failures to appear. The officer put low bond as a bond preference. That's what I have on my sheet. I don't know if you have something different. I'll assume because there's no prior history. The allegations are serious allegations, though distributing materials with a minor allegedly. The bond is $5,000 anyway, plus EMD with a stay away, no contact with the PW. Ms. McCall, part of that no contact is not disseminating anything.
Not posting anything?
Not posting anything regarding the prosecuting witness at all.
Or asking
Not-
anybody else to do it.
Yeah, no calls, no texts, no email, no social media. This person, if you know who it is, does not exist at all in your world. Are we 100% clear?
Yes, ma'am.
Because if someone pays the bond, and you do, that bond can be revoked. They could lose possibly their money and you could be rearrested. And I can pretty much guarantee that it will be much higher if you come back here. So are we clear so that you can stay out of jail? All right, thank you.
Thank you.
Grand jury date, January 15, 1/15.
Thank you.
McCree, Sierra McCree, family of LB.
Waive probable cause, Your Honor.
All right, ask the bond.
Ms. McCree is 36 years old. She lives by herself in College Hill. She tells me she's been signed up with a temp service for the past 3 months and she's been working part-time. She's afraid she's probably lost the opportunity to work there as a result of being charged with this. She has no money to post for bond.
From the state.
Given the nature of the allegations, state will be requesting a high secured bond with EMD and juris if requested by the family of the prosecuting witness. Allegations are that the prosecuting witness was 6 years old, disclosed to multiple family members as well as medical professionals that the defendant touched her on the outside of her vagina underneath clothing twice in the spring and early summer of 2025. Prosecuting witness was taken to Children's Hospital, the Mayerson Center, and interviewed completed a forensic interview there where she made disclosures consistent with what she had disclosed to her family members. Those family members were also interviewed, and the prosecuting witness's mother indicated that the defendant had admitted to her that she had bathed the 6-year-old child in the middle of the night, and mother was concerned because there was no reason given for why the defendant bathed that 6-year-old child in the middle of the night. These are very serious allegations. State has concerns for both the community as well as the prosecuting witness and her family. So state will be asking for a high secured bond. EMD juris is requested.
There's one violent felony, 10 misdemeanors, 4 prior failures to appear. The bond is 25,000 secured on each count, plus EMD, plus juris, if requested.
Come see them.
Grand jury dates January 15, 1/15. Kalia South. Order, or request for a temporary protection order. Jerome Scott. No response.
Miss South. He's right up there. Go ahead. Attorney, right there.
Darren Nye for Miss Scott, or Miss South. I'm not waiving probable cause on this matter. The complaint in and of itself appears to be defective. There's no alleged victim plugged in, and there's no even any wording to indicate that this is there's any serious physical harm. And I know it says cause or attempted cause, but there says nothing about serious even in the complaint on top of that. So for probably the third time in 24 years, I'm not waiving probable cause, Your Honor. So you've signed it, but hold tight till we.
Your Honor, based on the complaint in its entirety, including all the captioning at the top, I believe the omission of serious physical harm was a clerical error by the officer. So state would move to amend to add serious physical harm to the complaint. We'll note that the allegations are that the defendant struck the prosecuting witness with a closed fist, a metal pole, a bed slat, and then attempted to stab him with a knife. Per the arrest report that I have, the defendant admitted all of this to officers when questioned at the scene. So I moved to amend the complaint to add.
I don't know if they're going to add the victim's name on there because there is no person listed either. I mean, I don't want to tell the state how to do their job, but we don't even have it's a poorly written complaint, obviously.
Would move to add the victim's name or identifying information to the complaint as well. The prosecuting witness's name is Jerome Scott, Jerome. Scott is common spelling. Omission of the victim's name from the complaint is not fatal to the complaint.
I will allow the complaint to be amended to add the prosecuting witness's name. The complaint has victim at least in one spot, but just does not put the alleged victim's name. So allegations against the person are there. Is there an affidavit that accompanies this?
I don't have one in my packet, but
All right.
I do not have an affidavit here, Judge.
Probable cause is found as to bond.
It's the bond. My client's 20 years old. She's got no children, went to Mount Healthy High School, 11th grade. She works at Kroger's currently. She's got no failures of peer, no record that I can see or score two. It looks like the bond by the officer deferred to the prosecutor. You've obviously heard my arguments about probable cause. She tells me that she can stay at your aunt's house.
Yes.
She can stay at her aunt's house. So we'd ask the court allow, based on what you've heard, her to hopefully have an OR bond so she can, and I understand that theoretically it's charged seriously, even though I still feel that there's issues as it relates to that. But the victim's not here in the courtroom today. We're asking the court to take that into consideration. She has signed the stay away order and is willing to stay away from this individual and has no reason to go back there. She did ask if she would be allowed with police escort to go back to the residence and get her belongings, which is what we're asking, Your Honor.
Yes, box 13 can be checked.
Was that checked out? Great.
Is there anything else from the state?
Your Honor, the prosecuting witness in this case is the defendant's stepfather, for lack of a better phrase, the boyfriend of her mother. Mother was present during the incident, was a witness to it, indicated that she was the one who took the knife away from the prosecuting witness. And again, the statements that the victim made and the defendant's statements matched each other as far as her using weapons to strike him and grabbing a knife.
So this is an F2. I agree with defense that it was a sloppily written complaint that was incomplete, saved only by the amendment today. As to on its face, there is nothing else provided. The officer deferred any bond preference to the state. Ms. South has no record at all as an adult or juvenile. The injuries that were noted by the officer on the safety questionnaire were scratches on the victim's forearm.
You can't have any contact. Don't put anything on social media about
And I guess I should put this on the DV questionnaire. The prosecuting witness only checked that they believed they were safe to remain in the home. They did not check anything about they were afraid that they would be seriously harmed and or killed, that they needed any assistance. They also only checked that they've engaged in aggressive disputes, but did not check any of the DV indicators that would increase the risk of another incident. Based on all of that, OR plus EMD plus juris if requested.
Grand jury date, January 15,
Should be able to sign it
1:15.
the next day or two. They gotta call him and see if he.
Stewart.
Yeah, otherwise you'll get out of
Young
there.
lady,
Thank you, Your
don't
Honor.
make restaurant come necessarily, you are going home, okay? Not today. You are OR plus EMU. It works. Get a very good attorney, give him a call. Just do a full attention, go right in the middle next to your attorney, please, full attention.
Waive probable cause, Your Honor.
All right, ask the bond.
Mr. Stewart is 47 years old. He lives with his mother in Westwood. He's currently unemployed without money for bond.
From the state. You waive probable cause.
I did, Your Honor.
From the state.
Prior act robbery and carrying concealed. These are all, both older offenses. State will request no firearms as a condition and defer as to bond.
Mr. Stewart has 2 prior violent felonies, 1 felony, 1 violent misdemeanor, 2 misdemeanors, 0 prior failures to appear. Officer had no bond preference. On the F5, possession of 1 meth pill. OR. On the F3, possession of cocaine. $5,000 anyway, or alternative 2,500 plus EMD. On the illegal conveyance, F3, 5,000 anyway, or alternative 2,500 plus EMD. On the trafficking, F3, 5,000 anyway, or alternative 2,500 plus EMD. On the driving under suspension and the improper signal return, what level is the driving under, is that unclassified?
It is.
Oh, wow.
Grand jury date, January 15, 1:15.
Thank you.
Do we have Young?
750 plus evening,
Oh,
about $900 plus, Okay.
I don't remember if it was you or somebody else.
Macy's.
Or something.
I'll come back. I'll give you my-
We'll be here.
We'll be here.
Yep, we get upstairs, we'll add them up.
I'm sorry, who's next?
John?
Thank you.
So right here, like, to your attorney, so that's right, wait, on you.
So this, it looks like was put in here, the magistrate wrote this should be a felony, then put it in today. The bond was 10,000 and 10% plus EMD plus tag committed on the bond. Is the state,
So, Your Honor, I have this as a first and 10, fifth overall.
I have 6 overall.
It's, according to my office, it says
It's 5th. All right. First and 10, 5th overall.
correct.
Let me change that. first in time. And then I have two convictions in 2011. And then two in 2014. Is that what you have?
Correct.
11, 14, 15. And then there was an accident, non-injury, refusal, and ALS.
Correct.
All right.
I don't see the refusal on my paperwork, but maybe it's on the ticket. I have an A, B, and C charge for 26 TRC 90.
Yes.
And looks like OBI, reasonable control, and open container,
Yes.
but also a refusal.
No, I'm sorry, not a separate charge.
Oh, okay.
This is just for the, to know what happened in the case for the OBI.
Thank you.
No, it's not. As
As to bond, Mr. Young is 44 years old. He lives by himself in Cheviot. He does have a very good job. It's at Pacific Manufacturing. He works in logistics. He was there as a temporary employee for 90 days. In November, they hired him full-time. So since November, he's been full-time. He's very worried about losing that job. It's a great job that he really needs to get to. He's a veteran of the Army, honorable discharge. He served for us for 4 years from 2001 to 2005. He has no fail to appear in the last 5 years, and his ORAS score is 1. And so he's desperately asking the court maybe for a supervised OR bond so he can get out of here and go to work.
Your Honor, what's the current bond?
10,000 at 10%.
Your Honor, I think the current bond is appropriate, given that this is a fifth lifetime of OBI.
But remember, when we talk about that, we're talking about 4 of them and nothing since, 2014? Is that right?
Mm-hmm. So it's the first in time. It is the 5th overall. The bond that was set by the magistrate is not an unreasonable bond at all. OBIs are easy to avoid. And so once you get the first one, second one, third one, it is very easy to avoid by all of the different methods to get around. And this is the allegations, and there was a crash. Or basically, if you, not saying that he did, but based on the charge, getting in a vehicle 5th time under the influence, anybody can be killed. There was an accident. This is not an unreasonably high bond for a 5th. So the court is keeping it. I will though take off the EMD. He shows up to court. I'm keeping the tab on because no alcohol is a condition of bond, but I don't see the need for the EMD. But the cash bond will stay the same.
Thank you.
Okay, above Aaron's court.
He's interested in, he will be interested in Veterans Court if the discovery shows that there's a reason to continue the case through Veterans Court.
Okay. Well, I'll just RNC it and then you can have it put in so he can do it.
Thank you.
All right, thank you. And then OR on the bonds.
Felony walk-in, I have Randy Knight
you can call them, I have a warrant, I'll be right back.
Court is in short recess.
They're Randy Knipe, Kanipe.
So I think that the misdemeanor for Mr. Knight is going to the AC, right? It's from October.
Yeah.
Okay. So I'm gonna go over there with him and get it set, but I'm gonna tell the felony attorney about it. He'll probably get it back that I'm not designating him.
Okay. That's fine.
That's not how we would normally do it.
Yeah. And then Bill was out the 15th.
113.
115.
115, okay. Okay, so your next court date for the felony is gonna be 115. Yeah, and then you can go to 117.
Where's 117?
It's other side of the hall, almost all the way down. Okay, like kind of across from where the metal detector is.
Okay.
Oh, we gotta wait for that. The judge is coming back briefly.
First. Before
We can waive these court dates, the grand jury court dates. If you want to be here, you can. We can not usually, we can waive your appearance. Right. You know, it's this court. I don't want to discourage people from going to court across the street. For the 115.
Oh, well, I can believe that.
That, she's gonna send that over to.
Court is back in session.
Will I have to be appeared for that? Yeah. Judge, this is Mr. Knight, and I submitted James Moore's designation. I think there's an unrelated missing.
Do you waive probable cause?
Yes.
Is there?
It was a side road.
Okay. As to,
Judge, since he's here today, the most serious charge before you is a 5th-degree felony. He's here today like he's supposed to be. We request OR.
anything from the state?
On the felony, requesting a stay away, no contact with Danita Coleman, who is a 2008 Buick Enclave that was alleged to have been taken.
Give me the name again.
Danita, Donita. Last name is Coleman, Coleman.
Supervised or?
Switch out there, buddy. When you're done speaking to your attorney, go across the hall to room 111 for that OR bond. We'll be expecting you over there.
Couple of you go exercise, you go around, you go get your stuff.
Let me put this stack on the desk.
I just think around. Wow, we're switching across the hall, room 111.
And then also 117.
I'm so glad you seen it.
She sent the.
Hey, wow, we're switching.
Hey, did she send, the misdemeanor went to the AC, right?
Yeah.
Okay, we're 117.
117, 111.
Okay. And you got, it's got to sign his OR bonds here. Okay, you got to sign your OR
It
bonds.
was so hot in here earlier.
At least I'm here on this one.
You all, they're always here for me.
Not this way.
Court is back in session.
Good morning, Mr. Bay.
It's a daughter.
Yes.
Your Honor, their plea is not guilty. Ask you to refer to the assignment commissioner. This is a situation that involves his daughter. The allegation is from about a week ago, a little over. They had an altercation at a restaurant where he was upset with her and she was upset with him. And the allegation is that he, according to her affidavit, smacked me in the neck, which at that point I broke out of his hold and threw my pop can at him. Since then, my understanding is she does not reside in the house any longer. But he's willing to sign the TPO and stay away from her. And he will do that. Judge, he has little in the way of prior record. I know he's I believe on probation to this court for something. But I don't believe that there's a domestic violence dismissal from 07 and nothing else like that on his record that I'm aware of. He is working right now, Judge. He's trying to comply with the alcohol treatment that he needs to do while he's on probation, and he would ask with the TPO for an OR bond.
From the state.
Your Honor, with execution of the temporary protection order, state will defer us to bond. All I'm seeing here is an OBI history.
As we say, the allegation is he slapped his daughter in the neck after he told her multiple times to take her hood off her jacket and tried to make her take her hood off. OR plus the TPO. Thanks.
Creighton.
Hi, sir. Your Honor, I believe we've worked out Mr. Creighton's case. After talking to both the city and the prosecutor, and the county, he's going to plead to the 351A charge and to both charges on the 315, both the A and the B. Or do I have that wrong? I think I have that right.
I think that's right.
You said 351A.
Which is the city case, yes, Your Honor.
And then
315.
315
A and B. And then the balance of all is being dismissed?
That's correct, Your Honor.
And these are all unclassified?
That's my understanding. Well, and then there's a turn signals, which I believe is a minor. There were no accidents on any of the cases. We would waive for the reading of the court's permission.
Sir, guilty plea is a complete admission of guilt. The driving without a license charges are unclassified misdemeanors. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. The turn signal violation is a minor misdemeanor. Maximum possible penalty is a $150 fine plus costs. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the 3 traffic charges?
Yes, ma'am.
And counsel waive and stipulate?
Waive and stipulate, Your Honor.
Finding guilty. How long has Mr. Lau Creighton been in?
Judge, I know he's been locked up one night on these cases. I don't know if there's any other nights of credit.
Anything from the state?
No, Your Honor.
All right. Why'd you miss court?
I had a daughter and a lot of
You know you can't do none of that in jail, right?
I'm sorry.
Judge,
Don't apologize to me, apologize to yourself, because you sat in jail for charges that you can't go to jail for. That's
Judge,
why I brought
well,
that
I
up.
was, well, I had.
He's not in trouble. I
Okay,
just
I
want
have-
you to realize that all of these charges, Judge, we couldn't lock you up. The only reason why you went to jail is because there were habeas bonds for not showing up. None of these charges carry jail. So just make sure in the future, if you get a traffic ticket, that you either get a hold of an attorney, get a hold of the court, don't miss the court date, because you literally could not, on the charge alone, be locked up. All right? It's 1 credit 1, remit the fines and costs.
Anthony Daniel.
I can't credit, I'm sure, we'll take her in a wedding holder. Daniel, right?
Would you let him plead no contest?
Oh, criminal trespass, yeah.
Your Honor, we tender plea of no contest. It's one count of criminal trespass. We would waive reading with the court's permission.
I don't know that we can waive on a no contest.
Okay, then we'll, that's fine.
I was saying, they want to do a no contest, and I don't think they can waive reading on a no contest.
That's fine.
All right. Mr. Daniel,
Yes.
a no contest plea is not an admission of guilt, but it is an admission of the facts alleged against you in the complaint or ticket. This is a misdemeanor of the 4th degree. Maximum possible penalty is up to 30 days in jail, up to a $250 fine plus costs, and a possible period of probation. You have the right to a trial to the court, to a jury trial, to have your attorney call and cross-examine witnesses, to testify or not testify, and not testifying would not be used against you. Are you under the influence of anything that would stop you from understanding what I've explained?
No.
You understand the charge, the maximum possible penalties, and your rights?
Yes.
And you are a U.S. citizen?
Yes.
And you wish to waive your rights and maintain a no contest plea to 1 count of criminal trespass?
Yes.
Can I have the facts, please?
On or about January 5th, 2026, Hamilton County, Ohio, the defendant did without privilege enter onto the premises of United Dairy Farmers located at 3941 Montgomery Road in Norwood. The defendant was observed by employees of that UDF store as well as on video surveillance. He was on the property in the parking lot in front of the front entrance, waving at the employees through the front window and running away when they went to ask him to leave. He had previously been trespassed by those same UDF employees on an earlier date.
Your Honor, the only thing I have on the facts is just to emphasize he never entered the store. He tells me that he had a friend that he saw in the store. That's who he was waving at.
Finding of guilty, mitigation.
Judge, by way of mitigation, he has stable housing in Bond Hill. He understands he needs to stay away from both the inside of the store and the property of the UDF. And I told him all UDFs because they're all corporate owned. He was arrested about 8:30 last night, spent the night in jail. I think he understands he needs to stay away. He was cooperative with the Norwood police when they came upon him just down the street.
There are 2 prior misdemeanors, no other records, 0 failures to appear. Is there anything from the state?
No, Your Honor.
1 credit, 1 remit the fines and costs.
Okay.
Thank you, Your Honor.
Downs,
We'll go back to it.
Gregory Downs.
Grab your hat and go on. Down.
Judge, on behalf of Mr. Downs, plea is not guilty, as he referred to the assignment commissioner.
Bill, next to your attorney.
Your Honor, this is an allegation that he possessed a stolen air compressor. He tells me that he bought it at Lowe's about a year ago. He has stable housing, and he was trying to sell it to raise some funds online, and we would ask for an OR bond, given the nature of the charge.
From the state.
Asking for stay away, no contact from McCade and Connor. Here's this was a stolen Milwaukee air compressor. Attempted to sell it. I have no further information.
There's 9 prior failures to appear, OR plus EMD.
Go home with a simple person. Or turn me off.
Duffy,
Just last hallway. Or close to you. Duffy? Yes, sir.
Your Honor, on behalf of Mr. Duffy, there's 1 pedestrian violation, which we would try to, which appears to be totally unrelated, which we would ask to take care of. And the remainder of the charges is not guilty. Has to be referred to the assignment commissioner.
Is this a guilty plea?
Yes, Your Honor, guilty with pedestrian violation.
Mr. Duffy, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalty, do you want to maintain a guilty plea to a pedestrian violation? Yes, say it out loud.
Yes, ma'am.
Counsel, do you waive and stipulate?
Waive and stipulate, Your Honor.
Finding of guilty, Mr. Duffy's been in one night.
He has been.
Anything from the state?
No, Your Honor.
Anything else?
No, Your Honor.
On credit one, remit the fines and costs.
Your Honor, on the other charges, I believe there's some capious bonds. There's one of them which is a probation violation. That's the 22 case number. And then there's a 2024 criminal trespass for the same store. And then there's a yesterday driving series, which is how he ended up in custody and ended up here today. He understands that he can't drive without a license. I've talked to him about that. He's been working construction, and he was living off Beekman, so he has stable housing. We would ask for an OR bond. He understands he needs to come to court, and I've got good contact information for him.
From the state?
Asking for a stay away from all Home Depot stores. This was a criminal trespass. Defendant has been banned from all Home Depot locations as of 3/4/22.
Right, there are capious bonds of 5,000 on these. It'll be the same bond or alternative OR EMD because there are 4 prior failures to appear, plus the stay away from Home Depot on all of the traffic offenses, OR.
Sit down 10 minutes before that.
Thank you, Judge.
Anthony Ellick,
Judge, grab them, and you left. 10 minutes.
prosecuting witness on Anthony Ellick.
In the middle, next to your attorney, gonna get the way.
Prosecuting witness is approaching the window, Judge.
Mayor Stolman will take care of the rest.
Good morning, ma'am.
Your Honor, the plea is not guilty.
I got Ohio ID for a, what's it for thing? Sheila Weekly?
Good morning, Ms. Weekly. What would you like to say?
I want to drop the charges. We got 6 kids. Today is daughter's birthday. And, you know, the protection order got violated because we was trying to give my baby a party. You know, today her birthday. That's why we was even together.
Anything from the state?
There is a pending domestic violence charge in front of Judge Winkler. Can't tell from this if that's still active or not. Looks like it is.
It appears to be active.
Yeah. Pending domestic violence charge in front of Judge Winkler. Allegation here is that the defendant and the prosecuting witness were in a vehicle together.
Based on the fact that there was no altercation, nothing like that, I asked for an OR.
The bond would be OR, but if you are not interested in the TPO, I can't do anything about it today, but you all need to contact attorneys so that you aren't arrested, because regardless of if you want him there, if there is a protection order in place, he could be arrested every single time, whether or not you want to be with him or not. So to protect both of you and so he doesn't end up in jail, you got to do it the right way and have the TPO dissolved. And you have to do that through the judge it's in front of. Okay? All right. Thank you. You'll be released soon.
Hayes, Darren Hayes.
Mr. Hayes? Please right to the middle, to your attorney, he'll be meeting you in a second. Yes, sir. Right there.
Yes, Mr. Hayes, plea is not guilty.
For EMU, I think they're right. I'll take it there.
Judge, I believe there are capious OR bonds. Is that correct on the couple of the older charges?
There are. Judge Silverstein, her charges put capious ORs on those. I don't change bonds up or down. So those will be what the trial judge set it at.
And then he has a new traffic series from yesterday, Judge, and we would ask for an OR bond on those. Just refer to the assignment commissioner.
From the state,
On the county matters, Judge, state will defer.
City will defer.
I'll do an OR. There's a felony holder, but the trial judge has OR on all his other stuff, so I'll keep it going. All right.
Thank you, Judge. These are holding. There's something else you're sorting out.
Jackson, Jemiah Jackson.
Your Honor, that resolves my cases. Thank you.
Thank you. Have a good day.
Jackson.
Patient
Morning.
waiting. Good morning.
Not guilty for Ms. Jackson.
Okay, can you read this?
I can, the criminal damaging?
Yes.
Yes, the victim is Annabelle Silvers. Allegations are defendant broke the glass window on the front door.
Okay.
Esteban, Your Honor, she is 24 years old. I don't see any records, so therefore no failures to appear. She does work. She does seasonal work. She just ended that seasonal work with DHL. She does have her STNA exam scheduled next week, next Friday. And she did classes, obviously, for that she has already wrapped up. She has 4 children at home, lifelong resident of the area. She does deny the criminal damaging. It involves her mother-in-law in some respect, and she indicates that it was not her who broke the window. That should be resolved in court. I'd ask the court to consider an OR. She can't stay away from her, though.
From the state.
Request to stay away from prosecuting witness.
County will defer on the failure to disclose.
Supervised OR on the criminal damaging, stay away from the prosecuting witness. All right. Thank you. Maxwell.
Sir Clarice Johnson.
Not guilty for Mr. Maxwell. Come up here, sir. Okay. Esteban? Yeah, Your Honor, he is 65 years old, lifelong resident, mostly lifelong resident of the Cincinnati area. He lives on Vine Street currently. He is retired, received Social Security. Your Honor, he did turn himself in when he learned about this. Allegations stem from something that occurred on the 1st. And he did turn himself in, he indicates, to the Elmwood Police. While this does involve a long-term on and off relationship, they do not live together. I did inform him he cannot have any contact with Clarice, the prosecuting witness, and he can stay away. They live apart from each other. He does deny the allegations as well. We're asking for this to our bond. No failures to appear on his record.
From the state.
State laws for stay away, no contact with Clarice Johnson. And the allegations are that the defendant and the prosecuting witness got into an altercation about whether or not he would order her an Uber. He then pushed her back onto a bed. She was unable to stop this due to a physical disability. He then smacked her in the face. And when he got up, tripped over a nightstand, which enabled her to get up and call 911 using his cell phone. Unless for stay away, no contact, EMD jurors if requested based on the allegations.
There's zero failures to appear. There is some record, looks like from the year 2000 and nothing after that, so nothing in 25 years. OR plus jurors if requested. Stay away, no contact with the prosecuting witness. Thank you. Nevins.
Keep in touch with me, okay? Go back there.
Hello, that's hallway, OR plus jurors.
Not guilty for Mr. Nevins.
Is there anything from the state outside of Mr. Nevins staying away from Kroger?
No, Your Honor.
Mr. Nevins has no record, no failures to appear, no record as an adult or juvenile. Allegation is theft of groceries, would be a supervised OR bond, plus stay away from Kroger. Mr. Nevins, you understand that if you go into a Kroger store, even if you don't take anything, that you can be arrested for trespass, or I'm sorry, for this bond can be revoked. You understand?
Okay.
All right, so don't go to Kroger. Thank you. It's an OR bond.
Ross, Jordan Ross.
Thank you, Your Honor.
Get a hold of her right now.
She's a good attorney, going home. That's important right now. Got her stuff? Fresh foot. Ross. In the middle, next to your turn.
Not guilty for Mr. Ross. As to bond, if I may be heard, he is 35 years old. He received this citation on December 22nd of 2025. He was due into court on the 29th. He was sent to the UC emergency psych ward that day on the 22nd. They actually sent him to Beckett Springs. He was there from the 22nd to the 29th. He's going to get me that paperwork. He did attempt to come into the courthouse on the 30th. He couldn't figure it out. He ran to several different locations. They kept sending him to the same place. I don't know if maybe the paperwork hadn't caught up yet. And then he did end up turning himself in at Coleraine yesterday. He's not a flight risk. He wants to take care of this. He just wasn't able to be there in court that one day. He did lose his job, unfortunately, because of this charge. He was working at the same HVAC company for the last 5.5 years. He understands no driving right now. He's just asking the court to consider an SOR. I have good contact information, and he has information for me as well.
State.
First in time, second overall. There's one prior in 2014. All tests were refused, no accident, and insurance was not shown.
Is this second overall or third?
I think it's second.
I have second in time, third overall.
First in time, second overall is what I had. I apologize if that's
No,
wrong.
so there's this one. There was one in 2014 that was dismissed, and then another in 2014 that was a conviction.
I have 2021 in Indiana.
Oh, I don't have out of county records right now. So that would be why I didn't know that. In that case, then yes, it would be, you said what year?
I have second in time, third overall. I have in 2014 in Hamilton County, 2021 Dearborn County, and then this. So those are the two priors.
Okay. In that case, then second in time, third overall, test refused, no accident, no insurance. And I do not see an ALS on file, so given the priors, I will request a public safety suspension.
There is one.
There is one.
Yeah, we'll look at it.
Stop asking questions a while ago. There is an ALS on file.
There is ALS
Correct.
insurance.
He does have insurance. He did not show it at the time. I can't show it today, but we will bring that into court later.
Accident
No.
and test or refusal.
Correct. Refusal. Sorry.
So the bond that was on is 20,000 plus EMD. The bond will be 5,000 anyway, plus TAD.
Is that on both or just the?
No, that's just on the A, OR on the B.
Thank you.
Last name is Titus, SCI.
Not guilty for Mr. Citus, sorry.
Seriously, from the state, I have that from the officer that he came in on his own, and the officer specifically put in the 527 that the officer is okay with the OR.
Defer.
OR.
Sherman. Is there a Terriana Thomas?
Nobody in there. Not guilty for Mr. Sherman. Come on over here, sir.
0 people in the crowd.
As to bond, Your Honor, he does have an APA hold. I do have good contact information, however, no violence in his record. While this is from March of this year, he was not aware of this, or 2025. He was not aware of that until he got served with it yesterday when he was arrested. Because of the holder, he is asking the court to consider a nominal bond perhaps of $100.
From the state.
As in first day away, no contact with Terriana Thomas. Allegations that he struck her in the face, causing injuries to her lip that were observed by officers.
Stay away, no contact with Ariana Thomas, 500 anyway.
County walk-in, Morris.
Good morning.
Good morning. Post bonds, Judge. Judge, they had given her paperwork that said she hit at 12:30. So I was across the hall doing a written plea that Mr. Merschbach authorized and then found out that it was on this morning.
That's fine, you're entering the not guilty plea.
Yes.
All right, it'll be the same bonds that were already posted, which was OR on the reasonable control, 1,000 on the OVI. What number OVI is this? Oh, it looks like first ever.
Yeah, first lifetime test refused. There is an accident. Those are leaving the scene, and insurance has been shown.
You said it has.
And there is an ALS.
All right, it is the same bonds that were posted.
Thank you, Your Honor.
Thanks.
Last thing on Ronez Johnson. This is the one where we did a probable cause on a weapons under disability with no underlying disabling felony.
Yes.
I don't know if I set a grand jury date because I was under the impression that that got dismissed. They will not set a date because it's not a misdemeanor. So I'm trying to figure out.
So is this on Johnson?
Yeah.
PC was not found. There was an OR bond, so we should still go to the grand jury.
Yeah.
Okay, that's an issue.
It's just probable cause to hold, but I'll always send them to grand jury.
Okay.
Huh?
I said, I'm still learning this part. Okay.
Who was the attorney on this?
I think he's still in the AC's office. It was